Thanks for joining me, Ms Legalista, aka Attorney Sheila. Glad to have you here. I am back for round two of the Tiger Wood versus Erica Herman, I guess, relationship blow up, fallout from the couple no longer being a couple. I guess that's called uncoupling now. But it looks more like a lawsuit when you have a situation where one of the parties who was staying in the household is stating that she was kicked out in violation of the law. We are in round two here, where Tiger Woods, and this is actually a trust, has filed a motion to compel. Let's take a look.
Yeah.
Defendant's motion to compel arbitration and stay the claims against defendant. This is coming out of Martin County, Florida. Erica Herman is Tiger's ex-girlfriend versus Jupiter Island Irrevocable Homestead Trust, which actually is holding the property. So it says defendant's motion to compel arbitration and stay the claims against defendant. Defendant Christopher J. Hubman, as trustee of the Jupiter Island Irrevocable Homestead Trust, the trust, moves for an order compelling arbitration of all claims in plaintiff's complaint and to stay the claims against defendant during the pendency of the arbitration, and states, okay, so they don't want this in court. They want this in arbitration, any and all claims related to it. Introduction. If you haven't seen the first video that I did, it may be worth taking a moment to go back and look at that now. But, and I'm going to put a big but on this, that complaint didn't necessarily have a whole lot of details in it. I have a feeling that this motion has quite a few more details in it, and that this is going to be our first look at what was really going on. I felt like there were some things missing in the complaint. I feel like we're going to get more information here. This is 21 pages. I think that one was only a few pages. Here's why I think that. In this action, plaintiff Erica Herman alleges that as consideration for certain services she performed for the past 6 years, the trust entered an oral tenancy agreement that gave her the right to live at 462 South Beach Road, Hobie Sound, Florida, the residence, for an additional 5 years. And that was in the complaint. Paragraphs 5 and 6. Ms. Herman alleges she negotiated the oral tenancy agreement with agents of the trust. And I wonder if she's talking about Tiger Woods, because that's probably who invited her to the home, right? In reality, Ms. Herman was invited to live in the residence while she was in a relationship with her former boyfriend, Eldrick Woods, who we know as Tiger, who continues to live in the residence with his 2 children. After Mr. Woods recently terminated the relationship, Ms. Herman was advised that she was no longer welcome in the residence. Ms. Herman responded to the breakup by filing this lawsuit, which contends that the value of her alleged oral tenancy agreement is in excess of $30 million. Ms. Herman claims the alleged oral tenancy agreement was breached when, following the breakup, the trust's agents locked her out of the residence, removed her personal belongings, and informed her she could not return. See the complaint, paragraphs 8 and 9. Additionally, Ms. Herman claims in excess of $40,000 in cash belonging to her was misappropriated. Paragraph 9 in the complaint. As a result of the actions of the agents, Ms. Herman seeks actual and consequential monetary damages, injunctive relief, and attorney's fees and costs pursuant to the Florida Residential Landlord Tenant Act. Ms. Herman positions her complaint as an action against the trust because she is required to arbitrate all disputes with Mr. Woods in a confidential arbitration before the American Arbitration Association. So these are actually 2 distinct entities, right? You've got Mr. Woods, the person over here, and this trust that is set up as its own entity. She has a confidential arbitration agreement with Mr. Woods. There is not or was not that type of agreement with the trust. So she can sue the trust over here in any sort of capacity, but she's got some restrictions over here if she wants to sue Mr. Woods because there's this confidential arbitration agreement. Specifically, at the outset of her relationship with Mr. Woods, Ms. Herman and Mr. Woods entered into a non-disclosure and acknowledgement agreement dated August 9th, 2017 agreement, a redacted copy of which is attached hereto as Exhibit A to reflect a true and correct copy of the agreement to arbitrate. Among other things, the agreement requires that any and all disputes, claims, or controversies of any kind or nature whatsoever between Ms. Herman and Mr. Woods are to be resolved by confidential binding arbitration before the AAA, and that's the American Arbitration Association. By suing the trust rather than Mr. Woods, Ms. Herman seeks to evade her obligation to adjudicate her claims in a confidential arbitration and instead seeks to gain leverage by litigating her disputes with Mr. Woods in a public forum. The disputes raised by Ms. Herman in the lawsuit against the trust are quite plainly disputes between Ms. Herman and Mr. Woods. The trust is saying, this is not us. This is about y'all. This is a personal thing. All disputes arise out of the breakup of their relationship, and all damages arise in connection with Mr. Woods' decision not to permit Ms. Herman to re-enter his personal residence following their breakup. Accordingly, the disputes raised by Ms. Herman in this action are subject to the broad arbitration provisions of the agreement, and Ms. Herman should be compelled to arbitrate her claims in a confidential proceeding before the American Arbitration Association, as she and Mr. Woods previously agreed. So let me stop here for a second, because what they're really saying is we shouldn't even be involved in this. This really doesn't have anything to do with us. This is really between Ms. Herman and Mr. Woods, and they really need to just figure that out between themselves. And can you just leave us out of this? They had a breakup. These things happen. And yeah, she's just trying to pull us into it so she can do it publicly, as opposed to just doing this confidential arbitration that was required under the NDA. Now, I'm putting this big asterisk there around this NDA because there is now a lot of concern about NDAs and how they're used, and not just with personal relationships, but in business settings also. And so things have changed from the time that they first signed that. I don't want to jump too far ahead, but I just want to point that out now. The other thing to notice here is, like I said, if you go back and look at that initial complaint that she filed, she calls the place that she lived in with him as her residence. And this trust refers to it as his residence. And this is interesting. It would be interesting to know whether or not there's some sort of agreement that has to be in place between him and the trust. I don't know. Those may be papers that are more personal to the trust and Mr. Woods. But I can imagine that a lot of this may come out so that we can get a better understanding of what's going on. Meanwhile, back at the ranch, I think I just clicked on the wrong thing there. All right, here we go. Factual background. And I'm only on page 3. The trust and the residence. On February 28, 2017, Mr. Woods established the Jupiter Island Irrevocable Homestead Trust. The defendant in this case, Christopher J. Hubman, is named as trustee. That same day, by special warranty deed, Mr. Woods, as grantor, transferred a remainder interest in the residence to the trustee of the trust while retaining a life estate in his individual name. A true and correct copy of the special warranty deed is attached here to as Exhibit B. I was just asking what that agreement was that allowed him to live there. Now we know he has a life estate. He can stay there for his entire natural life. Well, probably entire life. I shouldn't even say natural. We never know what that's going to look like in another 30 or 40 years, right? The only asset ever held by the trust is its remainder ownership interest in the residence. The only potential beneficiaries of the trust are Mr. Woods' children and Mr. Woods. No one other than Mr. Woods' children or Mr. Woods himself has any right to the trust's remainder interest in the residence. Meantime, Mr. Woods continues to own a life estate in the residence and has a right to exclusive possession of the residence during his lifetime. In 2017, after Mr. Woods and Ms. Herman commenced a relationship, Now I'm wondering here, because this was in February, so at some point in time in the same year, they commenced a relationship. Ms. Herman began living in the residence as Mr. Woods' invited guest. Mr. Woods and Ms. Herman never married. Further, neither Mr. Woods nor the trustee of the trust ever transferred any ownership interest in the residence to Ms. Herman. Plaintiff's claims. On October 13, 2022, Mr. Woods notified Ms. Herman that he was breaking off their relationship. At that time, Ms. Herman was informed that she was no longer welcome in the residence. Ms. Herman then sued the trust, claiming for the first time that she and Mr. Woods, allegedly acting as agent for the trust — remember I said that in the beginning, that's who I thought she was referring to — entered into an oral tenancy agreement relating to the residence. According to Ms. Herman, for the past 6 years, she performed services that were extensive and of an extraordinary nature in light of the overall circumstances and environment in which she lived. I would like to hear more. As consideration for her services, Ms. Herman allegedly lived in the residence pursuant to the oral tenancy agreement, which Ms. Herman alleges had approximately 5 years remaining at the time Mr. Woods broke off their relationship. Ms. Herman claims entitlement to injunctive and monetary relief against the trust because following the breakup, she allegedly was locked out of the residence, had her personal belongings removed, had $40,000 misappropriated, and was informed she could not return to the residence. Complaint paragraphs 8 and 9. Lest there be any doubt, Ms. Herman's claims against the trust are just thinly camouflaged claims arising from disputes directly between Ms. Herman and Mr. Woods. This is what the trust keeps saying. Leave us out, please. It is between the two of you. A, Ms. Herman's claims arise from the breakup of her relationship with Mr. Woods. B, Ms. Herman's claims arise from an alleged oral tenancy agreement reached with Mr. Woods. C, the subject of the alleged oral tenancy agreement is Mr. Woods' personal residence, which he shares with his 2 children. D, Ms. Herman's claim that she was wrongfully prevented from re-entering the residence involves conduct of Mr. Woods' agents acting pursuant to instructions from Mr. Woods. E, Ms. Herman's claims regarding the misappropriated $40,000 involves the conduct of Mr. Woods' agents. The trust is still trying to be left out of this. F, by claiming the right to occupy the residence, Ms. Herman's claims are directly adverse to the personal interests of Mr. Woods and his 2 children, who are the current occupants of the residence. G, by claiming damages against the trust, Ms. Herman's claims are directly adverse to the personal interests of Mr. Woods and his children because they are the only beneficiaries of the trust and because the only asset of the trust is the residence, which Mr. Woods shares with his 2 children. The trustee, H, the trustee holds legal title to the residence, whereas Mr. Woods and his children all hold equitable title to the residence. As a result, Mr. Herman's claim against the trust is necessarily Ms. Herman's claim against the trust is necessarily a dispute with Mr. Woods. The trust has filed a motion to dismiss the complaint with prejudice. Like I said, they want to be taken out of this. I definitely need to see that motion to dismiss. To the extent the court declines to dismiss Ms. Herman's complaint against the trust with prejudice, the court should compel arbitration and stay the proceedings, meaning go to arbitration with Mr. Woods and still leave us out of this. They are really in this leave us out of this position. Mr. Woods pending arbitration. After this action was filed, Mr. Woods commenced an arbitration proceeding against Ms. Herman before the AAA. The arbitration arises from the same set of facts and circumstances as Ms. Herman's claims in this action. It involves the same individuals who will be witnesses in this action, and it involves the same conduct that has been raised in this action regarding the removal or misappropriation of Ms. Herman's personal property. I would like to know who actually handled her personal property. In his statement of claim to the AAA, Mr. Woods alleges that Ms. Herman signed the agreement whereby she agreed to confidential arbitration of all disputes between her and Mr. Woods. Mr. Woods alleges further that after he broke off the relationship with Ms. Herman insisted that 1, she had a right pursuant to an alleged oral tenancy agreement to occupy the residence for an additional 5 years. Why would you want to stay in a residence with the boyfriend that had broken up with you? From a practical standpoint, I don't understand that. Not necessarily from a legal standpoint, but from just a practical one. 2, she was wrongly prohibited from entering the residence, and that could be entirely true. 3, her personal belongings were wrongfully moved from the residence. That could be entirely true. Who took her personal belongings and where are they? Where did they end up? 4, $40,000 in cash belonging to her was misappropriated. Where did that go? Additionally, the arbitration alleges that Ms. Herman initiated this action against the trust in violation of the arbitration provisions in the agreement. In the proceeding, Mr. Wood seeks a determination by the arbitrator that 1, the claims in this lawsuit are subject to arbitration. 2, there is no oral tenancy agreement entitling Ms. Herman to occupy the residence. And to be honest, I just can't imagine that they had some oral agreement that she would stay for another 5 years, regardless of what their personal relationship is. Maybe they did. Maybe they did. Okay. But some of this just doesn't make sense to me. 3, Ms. Herman is not entitled to damages in connection with the removal of her personal belongings from the residence or the alleged misappropriation of $40,000 of cash belonging to her. In other words, Mr. Wood's claims in the arbitration completely and totally overlap with these claims in the case. Okay, they're just saying they're all the same. They're all the same. Let it take place in the arbitration. Again, the trust wants out of this. So now they've got more information about the motion to compel arbitration and the memorandum of law. And this is where we get into some of the legal stuff. Sometimes I gloss through this only because it can be a little overwhelming to dig deeply into some of these cases, but we'll go through it and see what's here. The law is clear that arbitration agreements are strongly favored as a matter of public policy and will be enforced whenever possible. By suing the trust over conduct taken by Mr. Woods and his agents following the breakup, Ms. Herman seeks to flout her obligation to resolve all disputes with Mr. Woods in a confidential binding arbitration. Instead, in the context of litigation and the publicity that is likely to follow, which is how I found out about this, Ms. Herman improperly seeks to leverage a payment from Mr. Woods in an amount that no arbitral forum would ever award. Such gamesmanship should not be tolerated. $30 million is what she is asking for. A, the arbitration provision. In Section 3 of the agreement entitled Dispute Resolution, Ms. Herman agreed that the exclusive manner of resolution of any and all disputes, claims, or controversies arising between Ms. Herman and Mr. Woods of any nature whatsoever shall be resolved by mandatory, binding, confidential arbitration. In the agreement, it says they agreed that by agreeing to arbitration, they are giving up any rights they may have to a trial by judge or jury with regard to matters which are required to be submitted to mandatory arbitration. All right, let's scroll down here to the trust may enforce the agreement to arbitrate. Neither the defendant trust nor the trustee is a signatory to the agreement. Ordinarily, a non-signatory to a contract containing an arbitrary agreement cannot compel a signatory to the contract to submit to arbitration. However, arbitration provisions containing the language arising out of or relating to, in certain instances, can be construed to include non-signatories. What they're saying here is the arbitration requirement refers to Mr. Woods and Ms. Herman. The trust never signed that, was not a signatory, was not a party. So it can't really compel them to go to arbitration. But what they're saying is, hey, we actually have some cases here that says in certain circumstances, if the language says arising out of or relating to, it can be construed to include non-signatories. That non-signatories can compel them to go to arbitration. And they're saying here, there is some language in here that says any and all disputes arising between us of any kind or nature whatsoever. It says, thus, Ms. Herman's strategic decision to try to avoid the mandatory arbitration provision in the agreement by suing the trust rather than Mr. Woods does not determine the question of arbitrability because it is the nature of the claims and whether Ms. Herman agreed to arbitrate such claims that controls. All right. And then there's some additional information here on that about the nexus. All of this has to do with whether or not the trust can push this arbitration. Okay, it says also that I can't even say this word, that the arbitration should be decided by the arbitrator, whether or not this is going to take place. So then they've got some rules here that says the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement, or to the arbitrability of any claim or counterclaim. It says, while this is generally an issue for trial courts to decide, courts must delegate the authority to the arbitrator if the party's contract so provides. So that's what they're saying here. The contract says, hey, in order to determine whether or not there has to be an arbitration, you actually have to have an arbitrator figure that out. Okay, so they've got a lot of cases on that. I'm not going to go through all of those cases. Let's jump to motion to stay the proceedings, because here's the big piece here. Under both common law of Florida and Florida Arbitration Code, a case must be stayed pending the resolution of a motion to compel arbitration. There you go. That's what they're asking for. Conclusion. All of the disputes raised by Ms. Herman in this lawsuit against the trust are disputes between Ms. Herman and Mr. Woods arising from the breakup of their relationship and Mr. Woods' decision not to allow Ms. Herman to re-enter his home. Given the nature of Ms. Herman's claims and considering the pending AAA arbitration filed by Mr. Woods, the disputes raised by Ms. Herman are intertwined with and subject to the agreement and its broad arbitration provisions. Consequently, it is proper for the trust to compel Ms. Herman to arbitrate her disputes, and Ms. Herman is stopped from avoiding her obligations under the agreement. It says, accordingly, the trustee respectfully requests that this court enter an agreement granting the trust's motion to compel arbitration and staying these proceedings until the completion of that arbitration. And you've got the certificate of service, and then you've got Exhibit A. So let's see what these are. Oh, we've got some things that are redacted out. This is the NDA, private and confidential, totally redacted, except for this part that talks about dispute resolution and that the arbitration shall be administered by the American Arbitration Association. We've got some more here. Each of us understands and acknowledges and agrees that by agreeing to arbitration, we are giving up any rights we may have to a trial by judge or jury. And there we go. We have her signature, Erica Fallon Herman, and his signature, Eldridge Tiger Woods. And we have Exhibit B, which was the deed that was mentioned at the very beginning of this, listing the location of the property, the trustee's name, and that's it. That is it. So a few more details here, not as many as I would have hoped, but at least we now get a little bit more into this. Some things that I think were left out in the original complaint. And just to speak to that a little bit, I am a person who, I think if you're going to put something out there, then don't just put it out there and try to make it look like it's one-sided. Everybody knows that there was a personal relationship, right? Everybody knows that. That's just me, just my opinion. But I think a lot of people looking at this would say, okay, y'all were just girlfriend, boyfriend. Yes, he got into an accident. You took great care of him. You took great care of his kids while you were there. What was this business relationship component? And what was this 5 years? What about this 40,000 and the 30 million? So that sort of wraps it up. All of the information in the complaint, all of the information in the motion to compel this arbitration. And other than that, that's it. So if that brings you up to speed with all the information that you need for this, then go ahead and give us a thumbs up and don't forget to subscribe. Peace.